A family in Ohio spent 14 months trying to inherit a house, not fighting over who should get it, not disputing the will, just waiting for a court to give them permission to touch a home their mother had owned for 31 years. The house sat empty the entire time. Property taxes still came due. The insurance still had to be paid. A pipe burst in the second winter, and nobody could legally authorize the repair. By the time they finally received the title, they had spent $18,000 in legal fees and carrying costs. $18,000 to inherit a home that was always meant to be theirs. The document that would have prevented all of it costs between $15 and $60 to file. It exists in most states. It takes less than an afternoon to complete. Nobody told the mother it existed. She had a will. She had done what most people consider enough. It was not enough. There are 6 specific documents that determine whether a family can actually keep a home after the owner dies or becomes incapacitated. Most homeowners over 60 have heard of 1 or 2 of them. Very few have all 6. And missing even one of them can cost a family the home through probate delays, creditor claims, government recovery programs, or a legal default that nobody saw coming. This video covers all 6, what each one does, what happens without it, and why most people find out about them too late. The document that would have saved that Ohio family is called a transfer on death deed. Most people have never heard of it. Here is what it does. It allows a homeowner to name the person who will inherit their home the moment they die, without the home ever passing through probate court. No judge, no waiting period, no attorney fees eating into what the family receives. When the owner dies, the beneficiary presents the recorded deed and a death certificate to the county recorder. The property is retitled in their name. The process typically takes days, not months. Compare that to what happens without it. Probate, the court-supervised process of transferring ownership after death, costs the average American family between 3 and 7% of the estate's value. On a home worth $300,000, that is up to $21,000 in court fees, attorney fees, and administrative costs before anyone receives anything. And it takes between 9 and 18 months in most states. During that entire time, the home cannot be sold. It cannot be refinanced. In many cases, it cannot even be properly maintained without court authorization. The transfer on death deed eliminates all of it. It is currently available in 33 states, including California, Texas, Illinois, Colorado, Ohio, Arizona, and Washington. New York and Georgia both added it recently, expanding access for millions of homeowners who previously had no simple option. Florida does not use the transfer on death deed by name, but it has an equivalent called the Ladybird deed, which works similarly and will be covered in the next section. The filing fee in most counties runs between $15 and $60. The deed must be signed, notarized, and recorded with the county recorder's office before the owner's death to be valid. A deed sitting in a drawer, signed but not recorded, does nothing. It only works when it is filed. For homeowners in Florida, Texas, Michigan, Vermont, and West Virginia, there is a different instrument that does everything the transfer on death deed does, and one thing more. It is called a Ladybird deed, also known as an enhanced life estate deed. Like the transfer on death deed, it allows the home to pass directly to a named beneficiary at death without probate. The owner retains full control during their lifetime. They can sell the home, refinance it, or change their mind about who inherits it, without needing the beneficiary's permission for anything. But the Ladybird deed has one capability the standard transfer on death deed does not. It protects the home from Medicaid estate recovery. Here is why that matters. Every state in America operates a Medicaid estate recovery program. Federal law requires it. When a person over 55 receives Medicaid-funded long-term care, nursing home care, home-based care, community care, the state has the legal right to seek reimbursement from their estate after they die. The home is almost always the largest asset remaining, and the state can come after it. A typical 3-year nursing home stay, at the current median cost of over $9,000 a month, represents more than $300,000 in care costs the state can legally attempt to recover from the estate. That recovery comes from the home. The Ladybird deed legally removes the home from the estate at the moment of death. There is nothing for Medicaid to recover from. The family keeps the home, even if the parents spent years on Medicaid. But the Ladybird deed must be filed and recorded before a Medicaid application is submitted. The 5-year look-back rule that governs Medicaid eligibility means that transfers made within 5 years of applying can create a penalty period, delaying coverage when it is needed most. The window to act is before the need arises, not after. For homeowners in those 5 states with parents approaching the age where long-term care becomes possible, this is the most powerful home protection document available, and most of them have never heard of it. The first 2 documents protect the home after death. This one protects it while the owner is still alive. A durable financial power of attorney gives someone the legal authority to manage financial decisions on behalf of a homeowner who becomes incapacitated, pay the mortgage, handle property taxes, authorize repairs, make decisions about the home if a move into care becomes necessary. The word durable is the critical distinction. A standard power of attorney becomes invalid the moment the person it covers becomes incapacitated. A durable power of attorney remains valid precisely when it is needed most. Without one, when a stroke happens, when dementia sets in, when a medical emergency removes someone's ability to make decisions, no family member has automatic legal authority to act on their behalf. Not a spouse, not an adult child, not anyone. The only path available is a court proceeding called guardianship or conservatorship. That process takes between 3 and 6 months in most states. It costs between $3,000 and $10,000 in legal fees just to get the appointment. And during those months, the mortgage still comes due. The property taxes still arrive. The home can fall into disrepair or even foreclosure, while the family waits for a judge to give them permission to do anything. The Consumer Financial Protection Bureau is direct on this point. Without a valid, durable power of attorney, no family member has the legal authority to step in. And here is the detail that stops people cold when they hear it. A power of attorney cannot be signed after someone loses mental capacity. The document must exist before it is needed. Once incapacity arrives, the window to create one closes permanently. A durable financial power of attorney typically costs between $100 and $300 to prepare with an attorney. The guardianship proceeding it replaces costs 10 times that. This is the one that surprises people most when they find out it exists. A homestead declaration is a document filed with the county recorder's office that legally protects a specific amount of home equity from most unsecured creditors. Medical debt collectors, civil judgment holders from lawsuits, credit card companies that won a court order. Once filed, those creditors cannot force the sale of the home to collect on those debts. The amount protected varies significantly by state. Florida and Texas protect unlimited equity in a primary residence, meaning no unsecured creditor can force a sale regardless of how much the home is worth. Massachusetts protects up to $1 million for homeowners over 62. California protects between $300,000 and $700,000 depending on the county. Ohio protects approximately $136,000. It must be notarized and filed with the county recorder's office. In most states, it is completely free. The protection applies only to unsecured debts. It does not stop mortgage foreclosure, IRS tax liens, or mechanics liens from contractors. But for the medical bill that became a lawsuit, the slip and fall judgment, the credit card company that went to court, the homestead declaration makes that equity legally off limits. Here is the detail that matters most. When wealthy families buy a home, their estate attorneys file the homestead declaration before they leave the title company. It is not a suggestion on their checklist. It is a standard first step. For most retirees, nobody ever mentioned it existed. It takes 30 minutes. It costs nothing in most states, and it could protect hundreds of thousands of dollars in home equity that is currently completely exposed. A retired teacher in Clark County, Nevada, had her home stolen, not by a bank, not through foreclosure. Someone forged a deed, walked it into the county recorder's office, and filed it. The county accepted it without question. By the time she proved she still owned her own home, she was $4,000 deep in legal fees. The program that would have caught it within 24 hours was free. It existed the entire time. Nobody told her. Here is how deed fraud works. Scammers search public records, which are freely available online, for homes with no mortgage attached. A paid-off home has no lender with an interest in monitoring the ownership chain. It is an unguarded asset. They forge a deed, file it, and then either pull a loan against the equity or attempt to sell the property outright. By the time the real owner finds out, the damage is already done. Most counties in America now offer a free property fraud alert program. It takes 5 minutes to sign up. The homeowner enters their name and property information through the county recorder's website. From that point forward, anytime anyone records anything against the property, the homeowner receives an email notification within 24 hours. A deed, a lien, a transfer, anything. That one notification would have caught the fraud against the Clark County teacher the same day it happened. Search the words "property fraud alert" plus the name of the county. 5 minutes, no cost. And yet the county has never sent a single letter to homeowners about this program. Not when they bought the home, not when they paid off the mortgage, not at any point. The program exists. The protection is real. Most homeowners have no idea it is available. The 6th document is costing people money right now. Every month they do not have it filed. Almost every state in America offers a property tax exemption for homeowners, and most states offer an additional senior exemption that activates at age 65. These programs reduce the taxable assessed value of the home, which lowers the annual property tax bill directly. In Texas, the senior homestead exemption removes up to $100,000 from the assessed value of the home for school district taxes. In Florida, the exemption removes $50,000 from assessed value and caps how much the property tax can increase each year, regardless of how much the home's market value rises. In New York, the senior exemption was recently expanded to reduce assessed value by up to 65% for qualifying homeowners. In Georgia, seniors over 62 can receive a full exemption from school district taxes entirely. The annual savings range from $1,000 to $3,000 per year, depending on the state. Over 20 years of retirement, that is between $20,000 and $60,000. Here is why most seniors are not receiving it. It requires an application filed with the county tax assessor's office, and in most states, the deadline to file for the current tax year falls in the spring. April 30th is the deadline in many counties. The county does not send a letter explaining this exists. There is no notification when a homeowner turns 65. It is simply available, waiting to be claimed by people who know to ask. And for every year a qualifying homeowner has not filed, they have been overpaying. Not because of anything complex, because no one told them the application existed. The family in Ohio eventually inherited the house. 14 months later, $18,000 lighter, with a home that had sat empty through 2 winters and needed repairs that could have been caught earlier if anyone had been able to legally authorize access. Their mother had a will. She had done what most people consider enough. What she did not have was a transfer on death deed, the one document that would have transferred the home in 30 days for $60. What she did not have was a durable power of attorney, which would have allowed the family to manage the home during the months she spent in care before she passed. What she did not have was a homestead declaration, which would have protected her equity from the medical debt that had accumulated. None of these documents are complicated. None of them require being wealthy. None of them require an attorney for the simpler ones. They require knowing they exist. The transfer on death deed, files with the county recorder for $15 to $60. The Ladybird deed for homeowners in Florida, Texas, Michigan, Vermont, and West Virginia, the document that protects the home from Medicaid recovery. The durable financial power of attorney, signed before it is ever needed. The Homestead Declaration, 1 page, notarized, filed at the county recorder. The Property Fraud Alert, 5 minutes, free, available through every county recorder's website. The Property Tax Exemption Filing, 1 application, filed once, saving thousands of dollars every year. 6 documents, most of them free or nearly free. All of them sitting there, available to anyone who knows to ask. If this channel is giving you information that nobody else is explaining clearly, subscribing means you will not miss what comes next. The next video covers the one Social Security decision most people make at 62 that cost them an average of $182,000 over their lifetime. Most of them have no idea they made it wrong